All right, so some really huge news just dropped yesterday, June 28th, for the legal community, for the legal geeks, for people in administrative law. The U.S. Supreme Court has officially overturned Chevron deference. The case of Chevron versus Natural Resources Defense Council has been overturned. It's gone, it's no more. So let's explain what Chevron really was. Chevron was decided in 1984. It was written by Associate Justice John Paul Stevens, and it was a unanimous decision. Kind of shows how much things have changed. Not a single justice disagreed with this. Justice John Paul Stevens, he was a Republican appointee, but he was a little bit more on the liberal side of the court. And it wasn't really, when he wrote the decision, it wasn't really supposed to be some huge bombshell in the field of administrative law. It was kind of just supposed to be a framework for how courts handle judicial review when they deal with agencies' interpretations of statutes. So basically the idea was that the court does a two-step inquiry into the agency's interpretation of the statute, because the agency invokes a statute when they act. So they look at the statute first, and they look to see whether the statute is ambiguous with regard to the question at hand, the question of whether the agency can do what they're doing or not. Not just ambiguous in general, because obviously if you look to see whether a statute's ambiguous in general, you'll usually find that there's some ambiguity somewhere. So once the court finds that the statute is ambiguous, then you move on to step two. And step two is whether the agency's interpretation is reasonable. So basically, step one is a lot more complicated. Step two kind of gives the court room to work backwards from its conclusions a little more. But along the way, there are some more steps that have been introduced, which I'll get to, that have kind of come with, I guess, the increased skepticism towards Chevron. And a lot of this blowback that Chevron got recently, it was because it was allowing courts to be way too deferential to agencies, to kind of allow them to be lazy, to allow for administrative authoritarianism. At least that's how the critics kind of put it. They thought that it was unconstitutional even, that most importantly it violated the APA, that it just allowed agencies to function like a junior varsity Congress. And especially those in the conservative side, they took issue with this. Although, of course, it was written by John Paul Stevens and joined by justices like Antonin Scalia and William Rehnquist. Those in the modern conservative movement have really come to hate Chevron deference, criticize it a lot. And with the Supreme Court now becoming 6-3 conservative, well, the chickens have finally come home to roost and it got overturned. And it's not really that surprising. So even though it's an important decision, even though it is a bombshell, it's not really a surprising one at that. Because in the past few years, the Supreme Court has really been ignoring Chevron, not really treating it like it's that important, like it's something that they need to adhere to. They didn't officially overturn it, but you kind of saw that it was on its way out the door. Basically, they were sort of adding new steps to Chevron too, like the major questions doctrine, which this is something that's really pretty recently, where when the agency is trying to do a sort of regulation that's really big in scope or something that the court thinks is of huge economic and political significance, they want to look at what the agency is doing and then look at the statute and presume that what the agency is doing is not authorized by the statute. And because they think that if Congress wanted the agency to do that, then they would have said it explicitly. So it's just another way that the courts can kind of strike down agency interpretations of statutes, say that, oh, it's not ambiguous, you actually cannot do this. So this was just another example of the Chevron framework weakening, and now it's officially gone. And yeah, it's 6 conservatives versus 3 liberals in the dissent, not all that surprising. I mean, another lesson from that is like, U.S. presidential elections matter. I mean, this could have gone a different way if a certain presidential election along the way had gone differently. But yeah, 6-3 along exclusively party lines. One of the things that's going to be really huge going forward, obviously we don't know the exact impact that overturning Chevron will have on the country, but one thing we know is that law students who take administrative law are going to be in for an entirely different curriculum, most likely. They might still read Chevron, but like they're going to have to read Loper Bright Enterprises, that's for sure. And they're going to need to know that Chevron isn't good law anymore. So there's going to be a lot developing. I saw a funny meme that showed like a picture of an administrative law textbook in a trash can. And it's like, yeah, this is basically what happened after Chevron for law students. So yeah, entire admin law revamp. Also for the entire country, I mean, it's going to be a lot harder for agencies to win in court. Courts can't defer to what they say anymore. And sort of where that came from originally was the idea of the deference was that the agencies are experts and the judges are not. So the judges shouldn't disrespect the agency's expertise on the issues that they're tasked with dealing with. For example, like the SEC, Securities and Exchange, like they're experts on that, and the judges aren't always experts on it. So yeah, now we've got judges who kind of have a little bit more leeway to probe into the agency's decision, to say, oh, I don't like it, strike it down. Justice Kagan, in her dissent, kind of criticized the decision for authorizing what she called a judicial hubris, like that there's hubris in saying, I know more than the agency. My interpretation is correct. My interpretation of the ambiguity here of what the statute says. So yeah, it's just an all-around loss for administrative agencies, for better or for worse. Obviously, administrative agencies can make regulations which are quote-unquote liberal or quote-unquote conservative. So it's not necessarily a super partisan issue, even though the court split along partisan lines. But yeah, it's going to have a huge impact on our federal government going forward. It's going to make things a lot more inefficient. It's going to really open the floodgates of litigation, I would imagine. You're going to have a lot more people feeling comfortable challenging the actions of agencies because they're like, hey, the court can't defer to them anymore. I have a much better shot at challenging this and winning. So yeah, obviously we've got a lot to learn about how this decision is going to impact our country, how it's going to impact the federal government and administrative agencies. There's going to be a lot of twisted new case law from the U.S. Supreme Court and the federal circuits. But yeah, really fascinating times we're living in. Let me know in the comments, do you agree with overturning Chevron? Do you think that they should have replaced it with something else? And remember, Skidmore deference is still good law. Skidmore is still in the books. Chief Justice Roberts made sure to say that. So, but that's a whole nother video for a different day. But yeah, Chevron is gone. Let me know what you think of it. Obviously, law students are in for a pretty big change. And yeah, rest in peace, Chevron deference.